All right. Well, thank you for that introduction. And again, thank you for having me. So we're going to switch to a drastically different accent because as you mentioned in the bio, I'm from North Carolina. So my pronunciations might be a little bit strange to some of you, but yeah, what we're going to talk about today is legal concerns in transitioning to adulthood for those with disabilities and special needs. I get a lot of questions and there's a lot of misconceptions out there. And just so you know that during my presentation today, I'm going to cover a lot of specifics in terms of benefits that are available and a lot of legal strategies that can be used to plan around things. So if you miss something at the end, there's going to be a lot of resources and links that we can share with you, and you'll be able to be provided with those afterwards. So if you feel like you've missed something, don't worry. We'll be able to circle back, and of course, I'll take questions at the end. All right, and I'm going to try to make this topic interesting because I know estate planning can get a little bit dry, but this stuff is important, and I get a lot of questions in this. So let's go ahead and dive right in then. All right, so let's start talking. Let's start generally with the tools that are used during this transition. So of course, when somebody is under age 18, they're a minor under the law. So their parents are their natural guardians, or if they've been appointed a guardian throughout childhood, that person is their guardian, able to make all their decisions. But under Pennsylvania law, as soon as a person reaches age 18, they're considered to be an adult, and they're presumed to be able to have full agency over their own decisions, which is good. But that's, of course, that does not work for everybody. So there's a lot of tools in place, such as power of attorney, supported decision-making documents, guardianships, trust, able accounts, and multiple benefits available to help somebody live as independently as possible. You're going to notice throughout this that this area of law is wrought with all kinds of acronyms and everything. So one of the things I hope to accomplish today is to demystify some of it and at least show some of the differences between a lot of the terms you might hear. So the legal concerns, and it all starts with estate planning documents, because any good plan starts with good documents. And to the extent that a person's able to understand and sign legal documents, this is a lot of times the least restrictive option to ensure that a person has a person to be able to advocate on their behalf and make decisions if needed. But there are also financial concerns that we'll discuss that is very relevant to inheritance or leaving money to be able to support a person. So I'm going to try to cover all of it and without throwing too much at you at once. But again, I will certainly take questions as we go. So when I say estate planning documents, the most important document that can be in place for this would be somebody that's doing their estate planning in the second half of life, or any person that's an adult that would like to appoint somebody to be able to make decisions on their behalf. So the powers of attorney, whenever I use that word most generally, I'm talking about really 4 documents. Financial, so the power to handle finances and to make financial decisions. Healthcare, that's your general healthcare decision-making power. If any time a person is not able to make their own healthcare decisions, a healthcare power of attorney is the person that would step into their shoes for that situation. Living will determines, allows you to put on paper what treatment you would or would not want in a specifically end-of-life planning scenario. Then there's also a mental health power of attorney, which allows you to appoint a person to be able to make decisions concerning treatment specifically for mental health considerations, such as place of treatment and the ability to consent to maybe some trial studies or experimental medications that sound kind of scary, but note that experimental medication is a very large umbrella, and that covers anything from the idea to the moment of approval. So there's a lot that could be covered there. And all of these together really work to make sure that no matter what life throws at you, you can have a person to be able to make decisions for you without having to go through all of the time and expense and loss of rights that come with a guardianship. Then, of course, a last will and testament, that's more for larger estate planning. So for those of you that are parents or caregivers for a person with a disability, this is very important to make sure that you can put your wishes in writing so that when you're no longer here, you can know that your wishes will be carried out. So let's dive into that a little bit more, because this is one that I get quite a bit. So I want to start by talking about powers of attorney versus guardianship, because I'll get calls or people schedule a consultation and say, well, they have a child with a disability, and they know that when they turn 18, something needs to happen. And they may have been told or just kind of assumed that they need a guardianship. Well, that's not the preferred method to do it. And there's a lot of reasons why. But the power of attorney, again, a written document where you authorize another person to be able to act on your behalf. The standard for this, now I don't think I have a slide for this, but there's also supportive decision-making documents that are becoming more and more popular. So I'll touch on that for a second. The biggest difference between a power of attorney and a supportive decision-making document is whether or not the person has the authority to make a decision. So a power of attorney does have the authority to make a decision on your behalf. Now, that does not take the power away from the person with a disability. They can still make their own decisions, but that power is shared with somebody else. So if that person is not available, or take it into the financial point of view, the power of attorney would be able to talk to the bank, sign checks, and manage things on their behalf. And likewise with a medical provider, be able to talk to the doctor, get medical information, and if needed, make a decision. To sign a power of attorney, the person signing it must have capacity to understand what they're signing. Now, Pennsylvania prefers this over a guardianship because guardianships are a very restrictive measure. So guardianships have the same end goal. So the person that's appointed as guardian for a person with a disability has the sole authority to make decisions on their behalf. So there's a significant degree of loss of rights that come with a guardianship appointment. A power of attorney, again, you share it. So there's a big difference there. And Pennsylvania prefers a power of attorney because of the loss of liberty that comes with the guardianship. So that capacity, that word is used there. That's not a very high bar. So you don't have to be able to fully read all the legal jargon in there and fully understand it. But most generally, it's as long as the person that's signing the document is able to understand what I mean generally by, for example, financial decision-making or healthcare decisions, and be able to reasonably identify who they would want to be able to have that power. And as long as you can pass that bar, there's a lot of ways, even with physical disabilities, if a person cannot physically sign a document, but they have the mental capacity to understand it, there's still ways that it can be done, either through somebody else or by making a mark like an X or something like that. So as long as the mental capacity is there, this is most likely going to be an option. So I mentioned earlier that guardianship is a court process. So a court has to get involved to appoint a person to make financial and or healthcare decisions for a person. They have to have evidence that the person is incapable of making his or her own decisions, which has to be testified from a medical provider. But again, there's a loss of rights that come with this. And so why is this important? Because again, I mentioned earlier that when a person turns 18, they are presumed to be able to act on their own in their own capacity, and they're presumed to be an independent adult. There's a common misconception that a parent has that power because, of course, up until age 18, that was the case. And you were able to make any decisions on behalf of your minor child. But again, that presumption is there. So as soon as a person turns 18, it's presumed that they are an independent adult, which is a good thing for most people. But parents are sometimes surprised if they're not able to make a decision for their adult child. So the problem with guardianships there is that, and they're not all bad. There are times where guardianships are necessary if a person is totally incapacitated. But guardianships compared to powers of attorney are much more time consuming because, again, we're dealing with courts here. So usually whenever I have to file a guardianship petition, I file the petition, and then a hearing is going to be scheduled in front of a court maybe 3 months down the road. And then, of course, it's also in addition to the time consideration, it is a court proceeding. And so there's attorneys involved, which in the more time that it takes there, the more costs that are involved. And it's intrusive because now the guardians are having to file annual reports of your finances, your healthcare status, and all of this is filed with the courts. along with the loss of rights. But thankfully, Pennsylvania law presumes that guardianship is not necessary. So if the courts are doing their job correctly, then a person filing for guardianship over another person has the burden to prove that that person is totally incapacitated and completely unable to make their own decisions. And then only at that point would the court go on to the next mode of analysis, which would be who should be that person's guardian. But that first step should be covered. And now, unfortunately, on the ground, there are some problems with this, and there is not as much attention put on these hearings as there should be. But if things are being done right, the court starts by assuming that it's not going to be necessary.
So sorry, can I just ask one question, Landon, while we're on this piece?
Yes.
So did that, when the incompetency hearing, obviously the burden of proof is on the person petitioning for guardianship, it's not taken into consideration necessarily the person's IQ, correct?
Correct. It's not IQ. It's the ability to effectively make decisions, and especially on the healthcare side, the ability to give informed consent to a medical procedure is a good standard to use. But it does have to be the person's capacity does need to be shown under a medical testimony of some sort.
And it's a very high standard, right? So even if you've got a neurodevelopmental saying, oh, this person, this young adult cannot make decisions on their own, doesn't necessarily mean that that's it. The guardianship is awarded.
Exactly. Well, that's the way it should work. So if you read the law, it is a fairly high bar, and there's also a limited guardianship option. So Pennsylvania law allows for a more limited, which gets into an analysis of more specifically what this person is and is able to do. So that way, instead of a plenary guardianship, which is a finding of total incapacity and complete loss of rights, and a person needs to make all decisions on behalf of the other person, there is a limited option where if, for example, a person is able to make all of their own decisions, but somebody else should manage their finances, you can really tailor it. But yes, it should be a high bar, and in all honesty, should be more rare than it is. Did that answer your question?
It did. Thank you, Landon.
Absolutely. And so the process there is that we have to have proof of incapacity by a physician. And again, incapacity there is, and I don't have the exact definition in front of me, but essentially to find full incapacity, a doctor has to be willing to testify that this person is incapable of making decisions in any way. Because again, if you're found fully incapacitated, then you no longer have the ability to make rights on your own behalf. And so when I'm talking to people about this, I say that it's almost like invalidating your signature. An incapacitated person cannot sign a legal document. It's not a legally valid document at that point. So it's a very high bar, and it should be taken very seriously. But in order to start the process, you have to have the physician's testimony lined up. The person that's alleged to be incapacitated, the person that would be under the guardianship, is entitled to personal service. So a person, once it's filed, a person should be physically giving them a copy of the petition and explaining what it means, and explaining that there is a court date on so-and-so date, and they have a right to show up. Technically, if that does not happen, then you cannot move forward with the hearing. And then eventually down the line, you'll have a hearing in front of the judge, which the alleged incapacitated person has an absolute right to attend. And in most counties, this varies county by county, but a lot of them will appoint an attorney to represent the alleged incapacitated person to make sure that their rights are heard by the judge before a decision's made. So, and I'm not going to talk about wills too much, but again, they're important here, and especially for parents, because again, you put in writing what you want to happen to your stuff when you pass away, and your executor who would administer all of that for you. Anybody with any assets needs to have a will. They're quite important for estate planning. But speaking of wills, and that's mainly the main reason that was there, was just to kind of transition into another question that I get quite a bit, which is how is it what is the best method to leave money or an inheritance to a person with a disability? Because as we're going to talk about later, several of the benefits that are available to persons with disabilities they're means tested, meaning that there's a maximum amount of assets that you're allowed to have in your name. And so there's several ways that property can transfer when a person dies. And you need to be aware of this, because just because you name something in your will, and I see all too often that people have a child removed from their will, and I'll ask why, why are you disinheriting this child? And they'll say, well, they have a disability and I know they don't need to have things in their name. Well, that's a good thing to know, but there's a lot of ways around that. But then in addition to your will, there are properties that pass outside of your will. So, for example, life insurance and retirement plans, you have beneficiaries named on that. So regardless of what your will says, those assets are going to go according to what that account says. And so if you set up a trust or remove a person from your will because you don't want to leave them money that would jeopardize their benefits, but they're named as a beneficiary in your life insurance, then they're getting those life insurance proceeds. And your will has no say in the matter. So, a comprehensive knowledge of how your entire estate would be distributed is very important. But same thing with if a person were to win money or get a personal injury settlement or receive an inheritance. So if the person were to receive a certain sum of money, and it depends on what particular benefits they're receiving, that person's public benefits might be in jeopardy. Now, of course, if we're talking huge sums of money, if somebody's, has a rich relative that's going to give them millions of dollars, then that might be lifetime money. But let's say a well-intentioned relative leaves $10,000 to somebody. That's a good amount of money, and that can last for a little while, but that's not lifetime money. But it could be enough to kick somebody off their benefits. So that's something that you need to be aware about. And income is usually not. Income's also looked at depending on the benefit. And if a person is married, then that person's spouse's income could also come into play. So knowing what resources are available and what resources might become available in the future is very important for a comprehensive special needs plan. So options to deal with this. So, and I'm going to go over these in a little bit more detail, but there's special needs trust or supplemental needs trust. You might see that written both ways. It means the same thing. I personally prefer supplemental needs trust. It's the exact same type of trust, but it uses softer language, because I've spoken with several people that seem insulted by the term special needs trust because of stigma. And I think supplemental is a little bit more accurate for what it is, because the purpose is to supplement any benefits that exist. And then you don't necessarily have to fit any other criteria other than being disabled as under the definition that Social Security would use. There's also ABLE accounts. I don't remember the exact year. It's been in the last 3 or 4 years, Pennsylvania passed the ABLE account law. So this is also another method that works to have assets available for a person, but not counted as their assets for purposes of their benefits. And for smaller sums of money, if you see, for example, SSI, if that person's account gets up to, say, $2,100 and they need it to be below $2,000, then you've got a month to spend that down. So, go shopping, find something to spend $100 on. That's the easiest way. But of course, for larger amounts of money, that well-intentioned relative that leaves you $10,000, you're not going to want to spend that kind of money in a month. So let's look at some of these other options here. All right, so a special needs trust, I really want to update this to make it a supplemental needs trust. But again, the purpose is to supplement and not replace whatever benefits a person's already receiving. And so the idea, as with any trust, is money could either through an inheritance or gift be put into this trust and be managed by a trustee who would manage all the money in the trust and make sure that it's there for the needs of the beneficiary, which is the person with a disability. But under such rules so that it's not the person who's the beneficiary does not have direct control over how it's used and it couldn't be used in such a way that would replace benefits, because the goal would be to have money there if it's needed, but still to retain any benefits there that they might be eligible for. Able accounts are really interesting too, and they work they work for a lot of different scenarios as well. So the standard there is that they are for people who are determined to be disabled prior to age 26. And anyone can create it for them. So you could create it for a loved one, or the person with a disability can create it for themselves. But every beneficiary, so a person with a disability, can only have one account. So regardless of who it's created by, there can only be one account per person. And then there might also be, there's a loosely defined payback provision, meaning that if a person with an ABLE account needs nursing home care later in life, under certain circumstances, money in the ABLE account might be eligible to pay back the state after that person passes away. So that's one thing to be aware about with an ABLE account. But for younger folks, it's a really good option. And there's some benefits over trusts that make them desirable to a lot. But these differences are worth exploring, because not every plan is the same, and what works for one might not work for another. And so some of the restrictions on this account is that you can only put $16,000 per year into the account. And this is from all sources. So, if somebody got a larger inheritance, say more than $16,000, then ABLE account's not going to be able to spend that down quickly. And if you are getting regular amounts of money and adding it to the account to make sure that you're able to get that money out of your account every month, you want to make sure that you're not accumulating more than $16,000 per year from all sources. Also, specifically for SSI, an ABLE account can only have a maximum of $100,000 total. Without SSI, we've got over $500,000 that can be in there, but SSI is one of the more strict means tested programs, and so you've got that $100,000 limit there. The general confines of distributions from this account are for quote unquote disability related expenses, which is interpreted pretty broadly. So realistically, as long as the money's being used for the named beneficiary and there's some reasonable relationship between that distribution and a need of that person, it's probably going to be admissible. And unlike a trust, an ABLE account can pay housing expenses for a person on SSI without getting a reduction for in-kind support from that would normally come with free housing. So that's one big benefit is for a person on SSI, is that you can use an ABLE account for distributions that would not be permissible under a trust. Now, special needs trusts don't have those limits. So any of those limits, if you were to get a larger sum of money, and one of the common places where you see a big need for a special needs trust is if somebody gets an insurance settlement. So if somebody becomes disabled as a result of a automobile accident, for example, and gets a very large settlement from that, there is no limit on the trust. So the trust can protect a much larger amount of money, and you don't have to worry about the amount of assets contributed into there on an annual or overall basis. Now, there's fees associated. So when making a decision between one or the other, you just have to look at each case's circumstances, because the fees for managing ABLE accounts are relatively low. And trust, it all depends on your trustee. So there are a lot of organizations or institutions that can serve as trustees. So you might see banks, nonprofits serving as trustee to manage all of that money. And there's a fee associated with that. And then, of course, be aware of those limits on contributions. So contributions to an ABLE account must be in cash. You can't move stock, for example, into an ABLE account. A trust could be used by any type of asset. So you can put real estate, you can put stocks, really anything, any assets that you've got can be moved into a trust. So trusts have larger flexibility, but ABLE accounts they're much less costly upfront and in overall management, and they've got a little bit more liberal rules in terms of how it can be used. Again, And you're not confined to one, so you could have both. So without knowing anyone's individual circumstances, I can't tell you which one is better, but it's good to know that both are out there. And then I mentioned Medicaid Payback. So if a person needs long-term care, Medicaid's paying for it. They're going to bill that person's estate when they pass away. So you want to make sure that if that's a concern, especially if we've got a big sum of money, that that's part of the analysis. And I've had a lot of this quite a bit. But if you do have both, one thing I didn't talk about yet is that a supplemental needs trust can pay into an ABLE account. And so if you've got an ABLE account that's set up, this is a situation where if a trust can pay into an ABLE account and an ABLE account can pay housing expenses, then that's permissible. Don't ask me how. I don't make the laws. I just am supposed to know them, but that's a good planning option there that could come with having both. But all right, and so I've already used a couple of different acronyms. So let's look at the two most common ones that people get mixed up. And so I'm going to start talking about a little bit of different benefits that might be available. The two most common that people get confused about when I ask, what benefits does a person receive? They'll say, it's through Social Security. I don't know. Well, the unfortunate fact here is that they use very similar acronyms, but there's SSDI, which is disability. And a person that's getting disability is qualified for Medicare. And it's based on a person's work record. And I'll get into this, but it could be paid if that person that's disabled has their own work record that they can work on, then they could be paid through that. Or a person with a parent with a deceased or retired parent can draw SSDI from that parent's work record as well. SSI, on the other hand, is a needs-based program. So the disability insurance, they're not going to be looking at your assets to make sure you stay under a certain level. SSI, on the other hand, they will. And instead of Medicare, it triggers Medicaid health insurance. And then I've got my maximum payments there. Social, as you can see, there's a big difference in the maximum payment. So disability can max out at over $3,000 a month, whereas SSI would be $841 max, or $1,261 for a couple if both people are eligible for it. But you got to watch out for those asset limits because, again, in most cases, a person's total assets need to be below $2,000 to stay with SSI. So it's important to know if you're a caregiver or working with a loved one with a disability, if they're receiving benefits, it's important to know which one. And then they're only one letter off, but again, SSDI is disability. SSI is the supplemental security income. All right. And so SSI is a very common one and it's one of the first things that people start looking at when a person with a disability turns 18. Because as a child, they might get some Social Security benefits. And at 18, they might lose those unless they're still enrolled in school, because in most cases, you can stay in school up to 21. Or if they're found, but if they're found disabled under the adult criteria, which is using Social Security definitions, then they might be able to continue that Social Security under the SSI program. And then if you were to do an application and be denied, you can appeal any denial within 10 days and continue benefits. So if they say for whatever reason, you're losing your benefits, you can appeal within 10 days and your benefits will continue during the period of that appeal, because that's not a quick process. And if that needs to happen, attorney's fees are limited by the Social Security Administration. So don't think just because you get a letter from Social Security saying you're being kicked off benefits that there's no recourse there. All right, and there's another one here that's less known, but it's a really interesting way to get medical insurance for a person that is able to work. So, of course, in both of those, I mentioned that if you have SSDI disability, you can get Medicare. If you have SSI, you can get Medicaid. But what about a person that doesn't really qualify for either of those, but is not able to work a full-time job to be able to be fully self-sufficient enough to pay for their own health insurance out of pocket? There's medical assistance for workers with disability, or MAWD, which with my accent is pretty easy to pronounce. So here's a little bit of qualifications for that. Got to be at least 16, under 65, and employed and getting paid. That's a very broad scale. As long as you're doing some level of work and getting paid for it. This could be minimal hours, but as long as it's something, then you would fit this requirement here. That this person does have to be disabled according to Social Security's definition. And you can't get this if you're getting SSI. So it's either SSI or medical assistance, or MAWD. But again, if you're getting SSI, you're qualified for Medicaid. So your medical insurance would be taken care of. And they don't use the regular income standards, but your countable income, it needs to be below 250% of the federal poverty income guidelines. That's a sliding scale year to year, but I've got your 2022 numbers in there. So total income that they would count below $2,831.25 for a single person, or $3,814.58 for two married people. And then countable resources. So again, this is your overall assets below $10,000. And I mentioned, so not all earned income is counted because they disregard some of it. And so it's possible to earn other incomes and still be eligible for this. And I've got a website there that kind of parses this out. So instead of making a slide that's a little bit too convoluted here, this is one of those resources that you can certainly get afterwards if you're interested. But there are some exceptions. So it's not just all the income that would go on your annual tax return. It's looking at specific types of earned income. And also pertinent to that $10,000 asset limit, there is no look back. So if you're not far over that limit, you can gift money and still qualify for this program. Unlike Medicaid, it does have a premium, but this is where your income becomes very important. So I said earlier that you can qualify for this even working low amounts of hours. Because they cap your premium at 5% of your income. Your countable income. So whatever that number is, you're capped at 5%. So if a person's only making $100 a week, they're not going to be, paying a huge percentage that would make it prohibitive. So that's a really good way to make the premium a sliding scale. So that way, theoretically, it should work for anyone who qualifies. All right, going back to SSDI and SSI. One of the questions that I get there is, how are they treated in terms of rent? Because if any of you are familiar with SSI or are working with a loved one who receives SSI, you've hopefully been advised that if that person is receiving free housing or food, then you get a reduction in the amount of benefits that they receive. So this is true for SSI. But now SSDI, that disability insurance, is not means tested at all. So if they're living rent-free in your house, that's not a problem. SSI, on the other hand, you don't want to have somebody living rent-free. So even if it's your child, for example, fast forward a little bit, they're already 18, they're receiving income. They're receiving SSI income, but they're still living with you. If they're not paying anything towards housing, then they could get a reduction in their benefits. So the way around this, and it always sounds, I get a puzzled look from parents when I recommend this, but you can charge that person rent. Now, I know it sounds weird to think that you would be charging your child rent to live in your house, but the idea there is that they're paying for their own housing, and it needs to be a reasonable rent. So you're not going to take all of their income, but based on their $800 a month income, charging something reasonable. So that way they're paying to stay there. And the idea there is that if you're charging rent, yes, that money's leaving their account and they don't have access to it anymore, but it's staying in the household, because if they're living there, they're still using utilities and contributing to bills, and there's taxes to pay, and there's groceries to buy and things like that. So it keeps it in the household, and it prevents you from getting that 1/3 reduction in the benefits. So you can still maximize the benefits and keep that money in the house. And remember, assets need to be below $2,000 anyway. So if this person has no expenses whatsoever, then their assets, it's very possible that their assets would quickly accumulate above the 2,000. So paying rent is a way to keep that those total assets below 2,000 and keep the maximum benefits that they're able to use. Because of course, if alternate placements were to be needed outside of the home, you're going to need the maximum income available to you to be able to pay whatever contribution they need there. And do note though that able accounts can pay rent without this deduction. So that's a good thing to note there. All right. And I'm going to leave quite a bit of time for questions here, but just to give you a little bit more, we got a little bit more background about our firm here. So we've got certified Medicaid planners, attorneys, and support staff that are really knowledgeable in this area of law, and everything is individualized. So we have our firm is experienced in all levels of estate planning, and we do not have a blind spot for any special needs planning. So any plans that we make, if we know that a person has a disability, that's going to be taken into account with knowledge of all this that would be available to them.